Hello, welcome once again to Lehto's Law. Today we're going to talk about whether or not you have the right to fish on a river on private property. And this was asked of me recently by somebody I know very well, but I've had this topic come up before, and it's an interesting one. And I'll admit, this might be unique to Michigan, but there are obviously other states that have rivers in them with fish in them, and you might want to go fishing in those rivers to catch some fish. And so then the question becomes, when do you have the right to fish on a river that's on private property? And that's the issue here. So the interesting thing is that it's a much more complicated answer than you're probably going to like, but it makes complete sense in a roundabout way. in only the way that a Michigan law could. So here's the deal. I know somebody who owns a fairly large piece of property in northern Michigan, and I'm talking about the lower peninsula, but someplace up in this general area. Beautiful area up there, and it's very, very easy to find some nice big forests and some rivers and some creeks and things that might have, say, trout in them. And I went trout fishing quite a bit as a child. I haven't trout fished lately, but the person I know who owns this piece of property told me that every spring and early summer he encounters people trespassing on his property fishing. And he's very nice to them, and he usually will go over and introduce himself and just say, by the way, just to let you know, you're on private property, which they know. And then he'll say to them, just so you know, I don't mind you fishing here as long as you're respectful of the fact that you're on someone else's property. And, I'm not going to open it up to the world and say, hey, everybody come on down and fish on my property. But, the fact that you're here, fish, knock yourself out, but just, be respectful. But the funny thing is he's told me that several occasions when he walks down there and starts, before he can even get the first full sentence out of his mouth, people will yell at him, go, hey, I've always been fishing here. I'm allowed to fish here. This river's owned by the state of Michigan. And then they usually get hostile at that point. I don't know if people appreciate the imitations I do of redneck America. But the thing is that the people who are yelling at him are wrong. They're trespassing. They are absolutely trespassing. So we're going to talk today about two primary things, and I just held up three fingers for some odd reason. I guess one and two. We're going to be talking about two things, and one of them is simply, when do you have the right to fish on a stream or creek that runs across private property? And number two, what does it mean to be trespassing on private property? Because I've had people argue with me about this also. I've had people tell me, they say, Steve, if it's not marked no trespassing, I can go there. I said, no, you can't. It's private property. You can't just walk on someone else's property. And I've had people say, they say, Steve, no. As long as it's not marked no trespassing, I can walk on it. Not how the law works, but we'll get to that. But I think that actually arose when I cracked the joke about how you'll be seeing a sign that says no trespassing. It's redundant because you're never allowed to trespass. If you were allowed to trespass, it wouldn't be trespassing. But we'll get back to this. So the bigger issue we're talking about today is fishing on creeks or streams or rivers, whatever you want to call them, running across private property. And so I'm getting this directly from the Law Enforcement Division of the Michigan DNR. And I apologize, the DNR may have changed their name. There have been a bunch of renamings and shufflings in Lansing in recent administrations where we had different divisions like the DNR or whatever, and then they combine them and they rename them, and I can't keep track of it. But the people who oversee the natural resources of our state put out a book or a booklet entitled Public Rights on Michigan Waters, and it's put out by the Law Enforcement Division of that department. And they start off with the introduction, and this is the kind of cheerleading introduction that you always see in Michigan. It's true, but they always like to point this out. The state of Michigan is surrounded by 4 of the 5 Great Lakes, the world's largest freshwater lakes. Those Great Lakes constitute 90% of the country's fresh surface water and about 20% of the world's fresh surface water. The Great Lakes are resources of vital national importance, utilized for manufacturing, shipping, drinking, recreation, and tourism. Michigan has approximately 3,288 miles of Great Lakes coastline, more than 10,000 inland lakes and ponds, and is interwoven by a 35,000-mile web of freshwater rivers, streams, and wetlands. Accordingly, Michigan has more boat registrations than any other state in the country. I believe Florida is number 2. At least they were the last time I checked on that. It comes then as no surprise that disputes arise between those who wish to utilize the waters and those who own private land through which these waters flow. And by the way, it's an interesting fact that Michigan has no lemon law for boats, despite the fact that we have more boats, like I said, registered than any other state. We've got lemon law for cars, of course, and some states have got lemon laws for boats, but Michigan does not. So there's a bunch of issues that arise when you have land that is either bordered by water or if there's water on your land, whether it be a lake, a stream, or whatever. And so, interestingly enough, the landowner is considered to have exclusive rights in the taking of game, either by hunting or trapping upon his or her own property and in open seasons. This right is a property right originating in ownership of land, and that right can actually be sold or transferred. Thus, one may own the land and sell the right to take game upon it. A parallel is the sale of mineral rights by the landowner, who may continue to occupy and use the land while mining by others is in progress. So I'm just pointing that out, that we're talking about the right to take game or the right to fish, and it's interesting, but these things are considered to be like, other rights, like usage rights or mineral rights. Now, in Michigan, riparian owners on inland waters historically hold title to the land under the water. Okay? It was therefore necessary to provide a legal avenue in which to convey rights to provide public fishing over private lands. So the water itself is owned by the state. Okay? But the ground underneath the water, as long as it's not a Great Lake, we're talking about the inland lakes or the inland rivers, creeks, streams, the ground underneath the water is owned by the landowner. Okay, it could be state land if it's a state park, for instance. But if you own a piece of property and a river flows across it, if you own both sides, the property and both sides of that river, you own the bottom of the river as well. You don't own the water that flows over it, but you own the dirt underneath it. That's extremely important. So the source of this right in Michigan is unique in that it is dependent in many instances upon the question of navigability of the water. So here's the thing. If I own a piece of property, it's a big square of property, and a river flows across it, and I own the property and the dirt underneath the river, the bottom of the river. If the water is owned by the state and no one can own the water but the state is pointing out that you have the right to be on the water so long as you're not touching the bottom, because touching the bottom means that you're trespassing on my property. But because the water flows over the property, if you can float on the water over the property, you are in state water. And the state water, by bringing you over my property, is the one legal way that you can pass through my property without trespassing. Okay? So, in Michigan, the right to take fish is shared by all, provided the water in which they are taken is public. So, here's what we're getting at now, and start thinking about these different rights. So, I own the property, I own the bottom of the river, but the water is owned by the state, and the fish live in the water. Now, I mentioned game earlier. There's deer. There might be game birds that you might hunt. Or if you hunt squirrel, there might be squirrels. But there's animals living on the land. That's game, okay? Game animals, I can hunt them if I own the property. You can't hunt them on my property without permission of me. But the fish in the stream, okay, live in the water owned by the state of Michigan. So you have the right to take fish out of the water, and you have the right to be present in the water so long as you are doing that without trespassing on my property, which is the banks of the river, of course, and the bottom of the river. Here's where it gets tricky then. And there's a lot of history in here. They say the state, in a case back in 1860, surrendered title of the submerged soil of inland navigable waters to the riparian owners. This transfer of title could not, however, transfer the rights of navigation or fishing or other uses of the water. So, for instance, there are rivers that they actually navigate and bring stuff up and down the stream. A boat might come into port at the mouth of the river, go up the river, drop something off, come back. you have the right to navigate on the river. And so, believe it or not, somewhere along the line, somebody came up with the idea that the best way to determine if a river or a stream or a creek is navigable is whether or not you can float a log down it. And that, believe it or not, was probably the first widespread use of the rivers, streams, and creeks by European descendants when they came to Michigan in the 1830s and after. And that is because there were huge forests with big trees in them. You chop the trees down and you roll the logs into the river and you build a sawmill at the mouth of the river. So the question becomes, if a river is navigable, well, what's the least thing you could do on it that would require some navigation? That's to float a log down it. So Michigan courts have repeatedly held that the public has rights in navigable water, and these waters have been defined as any water which in its natural state is capable of and has been used for the purpose of commerce, travel, and trade by the customary and ordinary modes of navigation. The floating of logs during the lumbering days was held to be an act of commerce. Consequently, any lake or stream used for this purpose would be considered navigable within the meaning of this term. Thus, the log flotation test has largely become the yardstick in Michigan to determine the navigability of a water body, and that is whether or not it is public or private. Okay? So we're talking about the floating log test. I'm not making this stuff up. So a navigable inland stream, it could be defined that way by a court. It could be defined that way by the U.S. Army Corps of Engineers. It could be any stream which actually floated logs during the lumbering days. And then they give some other definitions, but any stream having an average flow of approximately 41 cubic feet per second, an average width of some 30 feet, and an average depth of about 1 foot. But it says capacity of floatage during spring, and it again ties in with logs. And then it says any stream which has been or is susceptible to navigation by boats for purposes of commerce, and so on. So if a stream is deemed to be navigable, and it doesn't take much to float a log down a stream, doesn't require 6 feet of water. It probably only requires 6 inches of water. But the point is that that could make the stream navigable. The right to public use of navigable lakes and streams includes the right of trespass upon the submerged soil, but does not extend to the uplands of riparian owners while in such waters or in entering or departing from them. So the weird thing they're saying here is that even if there is a person who owns the bottom of the river, if the river is navigable, you are allowed to trespass upon the submerged soil. So you can, like for instance, if you're in a river, okay, the river is water owned by the state. The bottom is land owned by a private landowner. You can stand in that water, even though you're standing on someone else's property, because that's considered to be part of the use you can put that land to. The right to public use of the navigable stream. Okay? So then obviously it boils down to, think about this. If someone has a piece of property, a stream flows across it, and I want to go fishing on that stream, okay, I could walk across the property and fish in it, but I'm trespassing when I walk across the property if I do it without the permission of the landowner. But, you say, couldn't I get in the stream off the property and walk upstream as long as I stay in the water? I'm good, right? Yes, you're good, as long as that stream is navigable. And that's the tricky part. So the weird part about all this is that the Michigan Court of Appeals has ruled on this, and this is something that comes up over and over and over again. And it's fascinating because one of the rivers they're fighting over is the St. Joseph River, which is a river I've had my canoe in many times. Southwest corner of the state. It's over here. And I'll put up a picture of me and my canoe in the St. Joseph River in just a second. But there was a fight over that, and believe it or not, when they were in court, they never addressed the log flotation test. And so on appeal, somebody said, no one ever introduced evidence to prove that logs can be floated down the St. Joseph River. So therefore, you lose. And the Court of Appeal said, no. Something that's actually getting kind of archaic. What matters more is whether or not the river could be navigated, and this is the quote, by oar or motor-propelled small craft, i.e. a canoe or a small boat. And so if again, we're not going to get into the science of whether you can float a log down the stream. Could you do it in a canoe or a small boat? Okay, if you can, then it's navigable. If you couldn't, it's not navigable. So the Supreme Court, believe it or not, actually suggested that the Michigan legislature address this topic and make it more clear cut. But of course, they haven't done that yet. So here's the direct question asked by and answered by the state of Michigan. May I wade in a stream while fishing without being in trespass? And the answer is, on a navigable stream, the public has the right to float the stream, to wade on the submerged soil, and to fish therein. But this right does not extend to trespass upon the land abutting the stream, and it does not apply to non-navigable streams. And just so you know, trespass for emergency purposes to protect life and limb also will incur liability to the property owner for any damages done to the property under common law trespass. So the fact that you are in the stream and you have to get out and you say it's an emergency, doesn't matter, you're still trespassing. And by the way, and this is one of the things that I had somebody really arguing with me about, is that the right to fish extends to all non-navigable streams where the state is riparian. In other words, the state owns the stream. You can fish there. But you can still be found guilty of recreational trespass if you get caught on private property and you're wading in a non-navigable stream. So here, first of all, criminal trespass for fishing without consent on a private lake or stream, whether wading, floating, or fishing from the bank, can be sustained under the Recreational Trespass Act. And the stream is considered private if it's not navigable. The penalties for an infraction of this are quite severe. First-time offenders are charged with a misdemeanor. You may also be forced to surrender your equipment if you're fishing. And you may have to pay the costs associated with your prosecution. And then likewise, you can be hit for general criminal trespass charges if you are on a non-navigable stream fishing without the permission of the landowner. And finally, a landowner may initiate a civil action in a court of the county having jurisdiction against any person who enters his premises or land without permission under common law trespass. This action is possible whether or not the lands are enclosed or posted. You don't need to put up a fence. You don't need to put up no trespassing signs. So the idea that you can simply go onto someone's property because it's not posted is not true. And mere entry without prior authorization constitutes grounds for a common law trespass. Specifically, the common law trespass may be used against a first-time trespasser even though they've never been forbidden by the landowner to be there. So that's the key. If you want to go fishing on a stream on private property, first you can get permission of the property owner to do it legally. But if they won't give you permission, if the stream is navigable, you can go into it with a boat or a canoe, or if you want to, you can wade in the stream. But in the example of the friend of mine who described a stream to me, and I've seen it, his stream is not navigable. In fact, there's fallen things all over the place. It's about this deep in many, many places, and in many places it's narrow. You couldn't drag a canoe 100 yards up the stream if you tried. So whenever somebody goes and trespasses on his property to enter that stream, they're trespassing on his property and they're trespassing in his stream. It's just a question of whether he wants to do anything about it or not, or just continue to be a nice guy. But the point is that before you go fishing on a stream in Michigan, you need to find out who owns the land next to it, whether or not the river itself is navigable, and then, of course, if it is navigable, you need to stay in the river while you're doing your business there. That's the way it is in Michigan. In your state, obviously, it might be very, very different. Look it up. It didn't take me that long to figure this out in Michigan. So questions or comments, put them below. Otherwise, talk to you later. Bye-bye.